Americans for Fair Taxation presents the Weekly Chairman's Report, written by Steve Hayes, president of Americans for Fair Taxation, and recorded by Bob Paxton, a volunteer with the Florida FAIRtax Educational Association. And now, this week's Chairman's Report.
Hello, I'm Bob Paxton with the AFFT Chairman's Report for Friday, July 16, 2021. The IRS made a mistake, but Dyane Smith is still paying the price. In the June 11, 2021 Chairman's Report, we discussed the fact that a totally unjustified tax lien was almost filed against me by the California Franchise Tax Board, their state income tax agency. Now, my story had a happy ending. No tax lien was filed and the matter was dropped. I received the information below from Dyane Smith. Now, Dyane's an attorney who lives and works in Connecticut. Her story is very upsetting, and if you saw it in a movie, you wouldn't believe that it was even logical. After all, how could the government be this careless and this vindictive, and why? Now, here's the account that Dyane sent. This is a story of how the United States, through a combination of abuse of power by government agents and sheer ineptitude, undermines the public confidence that tax laws are being administered in a fair and equitable manner to all, and it offers good cause for abolishing the IRS. Now, I filed a lawsuit entitled Smith versus United States. My suit alleges that the United States, by and through its agents, the Department of Justice and the Internal Revenue Service, engaged in negligent, inept, wasteful, and deceptive conduct over a 20-year period. Their actions resulted in a failure to collect federal income taxes from a serial tax evader who actually owed the tax. Instead, they have harassed me for 20 years and have filed an invalid tax lien on my home. The facts conclusively demonstrate that the United States willfully abused its power, exercised poor discretion, and caused irreparable economic harm and emotional distress to her, a non-liable third party. The United States violated statutory law and disregarded IRS regulations and public policy that promote effective tax collection. Now here's the story. In 2003, my ex-spouse, David R. Smith, began a divorce action. During this process, David was assessed by the IRS for $66,987.83 in unpaid federal income tax debt due to serial tax evasion on returns that he filed solely in his own name. These were not joint returns which I signed. He filed married filing separately and was 100% responsible for the underpayment of federal income taxes. Now, David had a retirement plan with $1 million in assets. Under Connecticut law, the IRS could have entered a claim with our divorce court. Now, the court ordered distributions from his 401k to pay his other debts, and the court would almost certainly have required that David pay, or at least escrow, the $66,987.83 that he owed to the IRS. Instead, the IRS Chief Counsel, John R. McCulkus, decided not to file a claim. Now, I was not aware of David's income tax assessment. And the IRS waited to file its first tax lien against David on the marital home that I was awarded by the court until the time to petition the divorce court for an order that David may pay the tax debt had expired. This incompetent action by the IRS set in action a 20-year battle with them to remove David's liens from my family's home. Chief Counsel McCulkus wrote a memo revealing that the IRS knew that David fraudulently transferred $60,000 to his mother during the divorce action. The IRS failed to pursue David or his mother for tax fraud, but instead recorded a new federal tax lien against me personally without factual basis, labeling me David's alter ego nominee and/or transferee. And, despite David's documented testimony as to the offshore account passwords he set up by a convicted felon and his LinkedIn profile labeling himself as the principal in an investment firm, the IRS next deemed David as uncollectible. Thereafter, I sued the United States in the U.S. District Court seeking to remove the federal tax liens, and the government counterclaimed demanding foreclosure upon my home. The district court granted a default judgment against David, but exercised its equitable discretion to bar the United States from foreclosure on my home, citing the government's dilatory conduct as a primary reason that the tax debt was not effectively collected. The court further advised the parties to settle. Nevertheless, the Department of Justice, who handles all court cases involving the IRS, refused to settle. Notably, the IRS Attorney Group Chief Counsel John Carroll and the DOJ Attorney Julia C. Avetta submitted false sworn affidavits to the court declaring that David's debt was $154,166.75, more than double the actual amount, and when exposed, Avetta characterized the mistake as a clerical error when in fact the gross error was due to carelessly using the wrong tax years. 8 years later, David compromised with the IRS in an offer of compromise. Subsequently, the IRS failed to release the tax liens on my home as mandated by federal statute upon satisfaction of David's debt. Upon learning of the settlement, I filed a Freedom of Information request to disclose the OIC, that's the offer in compromise, but the government failed to meet the FOIA deadlines to respond and impermissibly withheld that offer in compromise. When initially confronted with the threat of a FOIA lawsuit, the Department of Justice denied the existence of an OIC, but it also stated it would entertain any settlement offer by David. The Department of Justice further represented it would consider release of the federal tax liens on my home. While this FOIA demand was proceeding, the Department of Justice realized that the IRS had violated their own rules by settling without a sign-off from the DOJ. The DOJ promptly rescinded the OIC that they said in the FOIA responses didn't exist, calling it void, and engaged in chaotic lien filings, including revoking releases due to mistake and recording a federal tax lien against yet another third party's home that David once rented 20 years earlier, even though he had no ownership interest in that home. My FOIA request did produce new incriminating evidence against the government in the form of a second internal memo. This is the Angata memo. The Angata memo clearly reveals that the government knew that its declaration of debt was false before it states a balance due on David's 2000 and 2001 federal income tax liens of $39,028. As of that date, nearly half the amount encumbering my home. Notably, the United States failed to disclose this memo during my quiet title action. Importantly, Angata's signature is affixed to the 2011 lien recorded against the plaintiff as nominee and/or transferee of David R. Smith, stating that the unpaid balance of $36,390.74. Despite this fact, the United States recorded a false abstract of judgment on my home in the amount of $66,987.83. That false abstract of judgment continues to encumber my home. Even after all their mistakes and misstatements, and although it is barred from foreclosure on my home, and despite the recommendations of the former National Taxpayer Advocate, and contrary to public policy, the Department of Justice and the IRS continues to refuse to release the tax lien on my home. Now, I'm now a senior citizen. In early 2012, I was diagnosed with PTSD, an anxiety disorder that was directly traced to my stress in dealing with the government's outrageous conduct. The collateral damage to my family life is incalculable. I was slandered and defamed in the small town where I was building a new law practice and denied access to my home equity. My parents passed away thinking their grandson and I might lose our home. Although I'm now disabled with PTSD and past the normal retirement age, I work to pay the interest on a falsely inflated debt. If they can do this to an attorney, imagine what they must be doing to millions of others who do not have the ability or the knowledge to fight for justice in federal court. Worse, despite the incompetence, actual false statements, and outrageous conduct that I have exposed, none of these government employees will lose their jobs, nor probably even be disciplined due to government immunity. If the FAIRtax was the law, I would have been spared the nightmare that has so adversely affected my life. Please join me in supporting the passage of the FAIRtax. While I pray it's not too late to save me, we must take action to save our neighbors, children, and grandchildren. Pass the FAIRtax. In conclusion, again, Dyane's story sounds like it can't possibly be true. How could our government be so brain dead and seem to delight in persecuting an ordinary, law-abiding American citizen? Dyane's complaint has all of the supporting documents that support what she says. The problem is not that Dyane will likely win and eventually get the tax lien removed from her home. No, the problem is that Dyane has been put through this living hell for 20 years. As Dyane says, the way to protect our neighbors, children, grandchildren, and ourselves is to eliminate the power of the government to perpetrate on us what they've been doing to Dyane for nearly 20 years. Pass the FAIRtax. If you have friends who don't know about the FAIRtax, send them to FAIRtax.org. Have them watch the whiteboards under how it works, and if they agree, ask them to please join us. Then, contact your members of Congress and the President and demand that Congress pass the FAIRtax, the only truly fair tax.
This has been the Weekly Chairman's Report, written by Steve Hayes, President of Americans for Fair Taxation. Check back every week for news and information about the fair tax, and learn why the fair tax should replace our antiquated federal income tax system. If you'd like to receive a copy of the Chairman's Report in your inbox every week, sign up at FAIRtax.org.